Is it doing that again? Of course, right when there we go. Hello, everybody. Welcome to the very first episode streaming live from YouTube and StreamYard. This is Bring the Jury with Luke and Brian Sheely. I'm Hannah. We are live from the Sheely Law Firm here in Columbia, South Carolina. Sheely Law Firm also has offices in Charleston, South Carolina. Today, we're going to be talking about the Alex Murdaugh updates, everything Becky Hill related. If you have any questions, feel free to drop anything in the chat. We'll be monitoring that. But yeah, we're just going to go ahead and dive right in, talking about just a general overview, what happened with Becky Hill, why is this important, and what does it mean for Alex Murdaugh? I'll pass it to you guys.
Well, it's, this kind of bombshell revelation that there was potential jury tampering by the clerk of court in Walterboro, South Carolina, Miss Becky Hill. The whole country is talking about it. Once Murdaugh's defense team filed a motion for a new trial on September 5th, so some almost half a year after the trial, and they file it based on interviewing jurors. And so whenever you file a motion, you want to back it up with, evidence. And so in this case, they've interviewed 2 or 3 jurors that were on that case, and they've given affidavits. But essentially, the big picture is that the clerk of court, and when we're criminal defense lawyers, and clerk of courts are very important. They help organize the jury panel. They help tend to the needs of the jurors. You always want your jurors to feel comfortable. You want them to be as least inconvenienced as possible. And they basically are the coordinators of the jurors who have the ultimate job of deciding whether someone remains innocent or whether or not by a jury of their peers are going to be convicted in South Carolina. So that's what we're accustomed to clerk of court doing. But in this case, based on the affidavits, they are basically the interviewing jurors who are saying that Becky Hill was talking to jurors about their opinions concerning the innocence or guilt of Alex Murdaugh, saying things to jurors about, you're getting right here, his testimony, don't be fooled by him. Don't believe what he says, look at his body language, insinuating that he's lying. She did a lot of other unique things. Granted, these jurors take an oath not to even talk to amongst themselves while the case is deliberating, or until the case is ready to be at the deliberation stage. They're not even allowed to discuss the case. They're supposed to be talking about how are your kids, what do you do for work, just kind of pleasantries, but not actually deliberating. So per the motion and the affidavits, sworn affidavits by the jurors, are saying that Ms. Hill was taking the foreperson aside and having private meetings, was taking juror number 785, who was apparently going to be not guilty. And she had questions about the state's theory, and she had questions about the evidence. And Ms. Hill was taking her and interrogating her in her office. And crazy parts of the affidavits, and again, it's already sworn testimony that's filed, that juror number 785 said that, we've seen a Facebook post from your ex-husband, and he's saying that you're talking about the case with him and that you're expressing your opinions on guilt or innocence. And so she's, number one, in disbelief, because this is an estranged relationship. And she's like, well, I haven't talked to that guy in 10 years. So I don't know what that's about. I don't know why he would say that on his Facebook. And she's like, oh, well, yeah, he sure is saying it. And by the way, how you feeling about the case? Because she's already kind of read the room with this juror that she's potentially going to be a holdout for Alex Murdaugh. And so, that gets brought to the attention of Judge Newman, and the defense is saying that this is not an actual post. This is a fabrication that Miss Becky Hill made this up about this ex-husband to try to get her kicked off the jury.
Well, we're saying it's a real post, it's just a different guy.
Well, that was the apology post.
Right.
The first post that was brought to Judge Newman's attention was, listen, this is an ex-husband. that he's saying, I just happen to be scrolling through social media and I see this post. I know this to be the ex-husband of this juror number 785. And, it says that, we've been drinking and talking about the deliberations. And then she interrogates the juror about this false post to, lend the backstory to Judge Newman. And she denies it, but I think we got to talk about this here, Judge Newman. And so, I'm reading this filing and they take the testimony. I mean, it's all transcribed. And so Judge Newman is saying, ooh, boy, I really don't like the fact that Ms. Hill has interrogated a juror as opposed to bringing a matter to me directly. So, Judge Newman knows that that's not a good way to be. And so she gets questioned about this Facebook post and she's like, listen, Judge, I haven't talked to him in a decade. I don't know why he would say that. Judge Newman is asking Ms. Hill, well, can you find this post for me so I can take a look? And Becky Hill is saying, well, I can't find it. And then one of her deputy clerks is saying, well, I found an apology post. He must have taken down the one that I saw last night, but here's this apology post by another guy, and the guy's name is like Tim Stone, but it's spelled differently and it has a different Facebook profile picture than what juror 785's actual ex-husband is. And so talking about drinking, and I apologize, and I was drunk, and I didn't mean to say what I said the other day, and it must have been the devil in me. And so that gets into the record. And so basically, this is all at the end of the trial. The closing arguments by Creighton Waters have occurred. And so basically, Luke, this juror 785 stays on the jury. But again, she's the one, per this filing, that has been identified as a holdout potentially for not guilty for Alex Murdaugh. And so then, essentially SLED gets, a tip, Luke, about about the same juror is now discussing her thoughts on the case to her tenant. And then this gets corroborated by the tenant's coworker. And so, SLED is also involved in the prosecution of this case, obviously. And some of these investigators that are finding these people in the middle of the night and asking them questions are also on the state's witness list. So one's a state witness list, potentially can be called in the trial or has been called, and one is actually an investigator in the case. And so then basically, the next day, all this comes about that, there's understandings that she's talking to more people, and then Judge Newman at that point dismisses her from the jury. So, and again, this is a situation where this juror refutes, of course, any communication with her estranged husband. And the thing about that post and that post fabrication from Ms. Hill is that it also really alarmed the juror, because she had restraining orders in the past out against her ex-husband, and per this juror's affidavit, Ms. Becky Hill is saying things like, well, I'll get those restraining orders back in place. We'll take care of you. Just tell us about this. And so, I don't know, Lou, you mentioned something, we were discussing this before we went live, but you almost say that Ms. Hill uses like a tactic. What'd you say about that?
If this filing is to be believed, and it's got affidavits, and we discussed, once we heard there was some big announcement, and once we saw this, we figured that you can't just throw mud on the wall. So it seems like they are prepared to present evidence through affidavits. It's not just hearsay. But yeah, and here it says that per the juror, the former forelady got kicked off, that she was asking, Ms. Hill, well, show me the Facebook post. I guarantee you I haven't talked to my husband and my ex in 10 years because apparently he's abusive. And Ms. Hill says, well, SLED agents went out there and he confirmed that post and that you told him these things. And it's just wild.
And did that ever happen?
No, it never did. So I think what I commented on is she's interrogating a juror. Let's just step back. Our elected official who's supposed to uphold the sanctity of her main function is to make sure that courthouse is running. And the biggest function is to uphold the sanctity of our judicial system by making sure those jurors have private, undisturbed opportunity for deliberation. She has taken this juror aside and confronted her with false information, which is what police do in some of their most high-pressure interrogations. That's a tactic that they use routinely. They're allowed to do it, but it doesn't look good later on when you realize they confronted you with a lie to get you to confess. It didn't work, but according to this filing, Ms. Hill was so invested in removing this juror because she may be potentially a free thinker or maybe embracing some, doing her job as someone who wants to hear all the evidence and hear all the closings before deliberating, that she wants to have her removed. I mean, it seems very much, if this is to be believed, that this is an engineered, designed way of removing this juror, and it seems like she's routinely taking the pulse of the jury by privately meeting with one juror in particular in the bathroom, on private walks. And you can't do that. They're supposed to be insulated and protected. And of course, Mr. Harpootlian and Mr. Griffin say this is all because she wants to enrich herself, that she knows that she's planning on writing a book, and that no one wants to buy that book about how, man, that murderer really got away with something. I mean, that'd be an interesting book, but it's not as good for Becky unless she writes a book about she was behind the scenes on the doors of justice.
I don't see how it really makes a difference. Like, I think the book would have been just as interesting had she just been honest and not, you know what I mean? Like, I don't know what story. I guess she was trying to have a happy ending for the nation because so many people wanted to see him.
Well, listen, and again, Becky,
but
clerk of court Becky is innocent until proven guilty. But this is wildly uncommon, unheard of, and seemingly very well sourced. So if and when there is a hearing, which I can only imagine there will be, I mean, the world will be watching, and it does make a lot of sense that Becky has lawyered up.
And just talking about because when you hear allegations like this that are, like Luke says, well-sourced, these are sworn affidavits, isn't just writing a brief by a lawyer, this is actual evidence in these filings. Why would a Becky do that? Why would a Ms. Hill do that? And, Hannah mentions about, the book deal is probably going to be the book deal, but I don't know. I mean, maybe you get to write a book if the case comes to a conclusion one way or the other, guilt or innocence.
right.
But if the jury hangs and there's no conclusion, it's just a hung jury, then maybe you don't get that book deal. There's no conclusion, it's just a hung jury.
It's a very meta experience that we just had.
And so, I mean, I think, based on the filing, it seems like Ms. Hill believed that there was one holdout, and all it takes is one holdout is enough to hang a jury. And it seems like Ms. Hill, per the affidavits, was taking the pulse of this juror frequently and didn't like, how many beats per minute it was running. But, in this brief as well, there's she's a public official. So no public official is supposed to use their position to enrich themselves by virtue of their position. So doesn't mean you can't have a side hustle and, have an Etsy shop of your hair dolls or something, but it's, you can't, what they're alleging here is that she's enriching herself from her position. She's motivated here by money and then ready to put the thumb on the scale of justice by talking, influencing, coercing, fabricating in the sanctity of the jury deliberation room. I mean, in our trial experiences, the judges are very clear at the end of every day, do not talk to your family. Do not even deliberate. Don't talk in passing to your fellow jurors about the evidence. You don't have the case yet. And then after closing arguments are over and the jury gets read the jury instructions, they get read the law of the land by the court, And then you think it's done. Well, guess what? It's not. And then the court says, do not, you're going to go back there. Do not go back. Do not start the process until the court reporter here and the attorneys get all of the evidence, the exhibits.
Go through it.
And only then, once it gets brought back to you, can you begin. And sometimes that takes, depending on a trial, certainly a 6-week trial, that could take an hour to make sure everything is organized and then no one's missing something. And only then are you allowed to even talk about it. So what's the standard? What's the standard for a new trial? And it's outlined pretty well in the defense brief. And it's kind of basically if there is a communication regarding, with the jurors by an outside influence, and if the subject matter of the communication wasn't harmless, basically, and it can affect the verdict, that's the standard. And so if a bailiff says, hey guys, you feeling Chick-fil-A for lunch today? Well, that's a communication, but it's harmless because it's not about the trial. It's not about guilt or innocence. It's not saying, don't believe the defendant's body language. Don't, let me interrogate you in my office for an hour about your feelings on the evidence of the case. Don't believe what he has to say. That juror shouldn't have handed him a box of tissue. That's what the defense wants us to do. I mean, that's the kind of stuff that was happening between the clerk of court and her jurors. The case law basically has been analyzed that the presumption is even stronger that the subject matter would have changed the outcome if it's from a court official. And there's cases about, bailiffs and other people, but essentially you have the herder, the boss of the jurors for 6 weeks, telling them when and where to go, what to do, how to do it. Now telling them how to feel about defense evidence. And then when she's not feeling that that's enough, she's fabricating social media posts by an ex-husband that never posted something and other things to get a juror off for gain. So jury tampering in South Carolina is a felony allegation that carries up to 5 years. Luke, I understand Ms. Hill has some lawyers already involved in her representation.
That is my understanding. I think Justin Bamberg, who's a fine lawyer, but one who has no problem speaking out publicly, and I think is a member of the House of Rep, if I'm not mistaken. And Will Lewis, who doesn't speak so much publicly, but is a very smart, talented, experienced former federal prosecutor. So she's got a couple there that might serve a couple different roles and keep her in good stead. It definitely means that she's taking this seriously, which she should, because these are just bombshell allegations. And at some point during whatever hearing that occurs in front of whatever judge that decides this matter, and we can talk about whether it should be Judge Newman or not, she may be called to testify. And then it's a question of whether she pleads the fifth or not about some of these allegations, which I suspect she will. But this hearing, whenever it occurs, will be an absolute free-for-all.
And the hearing, this filing doesn't just do it. This filing requests an evidentiary hearing, and that's the legal standard for an allegation like this of jury tampering is, let's have an evidentiary hearing. It's not just a bunch of filings back and forth. So at some point in the future, there will be scheduled, I imagine, a lengthy evidentiary hearing, and they will put these jurors on the stand and they will be examined as to the affidavits. The defense and the state will get an opportunity to examine them, as well as a court fact finder, whether that's Judge Newman, who's going to be asking the jurors questions about this. Now, the defense also kind of makes some points that, he's a witness to this potentially. And they do that because, he was there and he was observing Becky Hill. He was taking actions based on her communications to him about jurors. So he was there. He was in the mix of it. So, Judge Newman's a great judge. And so, there's been some talk about, well, can he be, take this on himself if he's potentially a witness? The question always is, well, can he be fair and impartial? And of course he would say, yes, I can be fair and impartial. Then there's some other questions he's set to retire in December, and it's September right now. So, I would think that this would get scheduled before.
Well, right now it's holding up an appeal.
Right. I mean, it is. So this motion has stayed the appeal process, and it is, it's back for an evidentiary hearing. Luke and I have tried a number of cases with Judge Newman as a presiding judge. And this reminds me of a case I tried about a decade ago where Judge Newman was the presiding judge, and we actually had a jury tampering kind of wrinkle in the case. And so, basically it was a domestic violence case where my client, had that charge pending. It was his trial day, and he was with me to pick the jury, and he was a smoker. And so we picked a jury, and we were getting ready to do opening statements. And I had a really good trial partner, and she was getting ready to open. And so, we had a 5-minute break, and then Judge Newman is very prompt on coming back from breaks. And so I started going downstairs to the courthouse and looking for my guy, and I saw him kind of walking away from where he would take a smoke. And so I went outside, and I was like, hey, what are you doing? Get back up here. Judge Newman's getting ready to hit the bench. And he just looked back, and he started moving faster, and I started moving faster. And he ultimately started sprinting away from me. I was like, hey, we need you. What are you doing? And he
This is not a good look.
I've always remember this. He looked up, he was fast. I was never gonna catch this guy. He was like, don't follow me, Sheely. Don't follow me. And he was around the corner. And so, oh my gosh. And so I was freaking out.
Our client just ran away.
And so get back up there, and, Judge Newman was just taking the bench when I got back in the courtroom, and where's your client? And my partner was getting ready to work on her, do her opening. I was like, Judge, he just sprinted around the side of the courthouse. He's gone. He's not coming back. And Judge Newman was like, all right, well, bench warrant for him, but let's start this trial. And so it's like your worst nightmare because
Have the jury come out yet?
No, he was going to bring the jury back out.
Okay, bring the jury. Okay,
Right,
I just
bring
wanted
the
to know if they knew that he
So
had sprinted away.
they didn't know that.
Okay.
They
And,
knew that he was there during jury selection.
right. So,
Right, well,
So
he
in-
was here, no, he's not, but he could have had, something.
So in opening statements, my partner, she was just like, hey, so I know you saw Mr., I'm not gonna say his name earlier, he had something come up. He had a real
He was really sick.
Jojo. I tried with Jojo. But the law says he doesn't have to be here. The state has all the burden, all the proving. He doesn't have to testify. He doesn't have to be here. And you're gonna hear from Judge Newman that same law. And so they're like, okay, well, we saw him and now he's not there. So we win the trial. And then they pick him up on the bench warrant, literally as the jury is coming back with the verdict. And so now he's in handcuffs, but the jury can't see that. And so all of a sudden he's back for the jury verdict to be read, and it's not guilty. Wow, he's excited about that. But here's the jury tampering part.
Mm.
So one of the jurors, when they came back in on day 2 of the trial, I can't remember, it was a pretty short trial, basically said, well, I know that the defendant was there earlier, and he wasn't there when we started with openings, but I will say I saw him running quickly down the stairs as I was coming up, and he did speak to me. They told a bailiff this, and there were 2 women, and he ran past them and he said, pray for me. And so he didn't say, what's your feelings on the case? He didn't say, can you convict someone without a murder weapon? He didn't say anything really big other than pray for me.
Little did he know that juror was a woman of God.
Right.
And-
So that was made known to Judge Newman, as it should be. So if that information gets made to a bailiff who assists the clerk of court in handling the jurors, that gets appropriately relayed to the judge. So we just, won this trial, and I'm all excited. And then Judge Newman says, well, we're going to take up another matter. Here's what I'm hearing about what I just said. And my guy thought he was getting ready to get unshackled, and he's like, oh. So after the trial, so what Judge Newman did is he did exactly what the law commands. It commands an evidentiary hearing to determine, number one, was there communication by an outside influence? And it's interesting here because, it's my client. So technically he could have testified if he had been there and actually interacted or told his story to the jury. But anyway, but basically did that communication, concern the subject matter of what the jury was there to deliberate about. So pray for me, I guess for my client would have been the subject matter, his well-being, and then did that communication,
Was it harmless?
Was it harmless? Did it have an effect? And so what Judge Newman did was he put those two jurors on the stand, and he asked them pretty lengthy questions about what happened, what transpired. And then he also allowed my client to testify. And so we elected to throw him up there. I think he was kind of a wild guy anyway. And he was like, yeah, I need to let him know, let it be anything. I'm just scared, Mr. Shealy. And so he got up there, and Judge Newman grilled him for a good bit. And then after keeping everyone kind of, tensely on pins and needles for the remainder of the day, he said, all right, well, I find there's been no jury tampering. I find your client to have made communication, but they're harmless. And he just did it in the moment. And I'm gonna find no jury tampering. And the other issue of contempt of court and just violating, court proceedings, and whether I want to, because, judges in South Carolina can also hold someone in contempt, like a 6-month offense. I find that, there's been no contempt. I'm all right. You can release this guy, and that guy was relieved, but Judge Newman is definitely going to, want to not only allow defense and the state to examine these jurors, but he's going to do his own inquiry. I guarantee you he will. He may do as much examination of the jurors as anybody.
Just curious, little law school 101. How was Becky Hill selected or chosen, assigned to be the clerk of court for this trial?
Well, she had a public election.
Oh, okay.
Yeah,
There's an
just
election for it.
Yeah, it's just like sheriff and everything else is clerk of court.
Okay.
And they, it's interesting. I don't know how much the average citizen consumer really thinks about the clerk of court, but they do campaign, and they.
Well, literally, I didn't know.
Because it's not like when you're voting, you're thinking about the important stuff in your mind, whether that's governor or president or mayor or whatever. And then some of the stuff you just, now you know how it affects the world.
This is the color I like, so I'll pick that one.
Some clerks are better than others, and some have backgrounds and levels of education where they're pretty good at getting stuff done and in a ethical way, and others, I know nothing about Becky's background, but it is an elected official, which makes it all the more interesting, which triggers these criminal laws that she should not enrich herself, which also, if you listen to him, I listened to Griffin and Harpootlian's big press conference on the State House grounds. They were talking about
Court of Appeals.
Court of Appeals?
Yes.
Okay. Well, it's part of State House grounds, but.
Oh, excuse me.
But,
So we did.
and they were referencing 1983 lawsuits.
That's right. They were saying that she's a state actor, which she is.
Which triggers federal lawsuits, wrongs done by people just like we've engaged in some of that. You sue the sheriff in his official capacity. Well, you sue Becky in her official capacity, and that triggers a lot of stuff. So it's not good. It's not a good thing. And whether, I'm really fascinated to see what Judge Newman does, because he is truly, in my humble, non-objective opinion, a witness, because there's a transcript here where he's questioning Becky about what she's relaying to the court. He even seems exasperated that she essentially questioned the juror before he got the chance to. That's really his purview. If there's any juror impropriety, information gets relayed to him, but he does the questioning. He's the one that decides whether that juror is excused or not. But the weirdness about this, judges are used to ruling on standard post-trial motions. And a lot of that is really for the lawyers to preserve the record if you lost and you think that you want to make sure the record's clear, and let's say it's some issue that you think Judge Newman should have done better on, you put it up there, very likely it's going to be denied summarily without a hearing. We've had a couple before Judge Newman and other judges, and that's the way it is. Sometimes you may get a little bit of a hearing, but pretty rarely, pretty mostly not. But so when a judge is at a sentencing, and Judge Newman is pretty particular about his sentencings. I mean, he takes them very seriously. He's sat there, in this case, 6 weeks. He pretty much tells you how he feels about you, whether that's good or bad. I mean, we've had sentencings where he's been very complimentary of our client, even though he's about to send him to prison, and kind of just muses about his life choices, but he's got so much intelligence or potential that he wishes him the best of luck, and here's your sentence. But in this case, and he always gives that defendant the opportunity to say something, usually incriminating, because if you say something incriminating, your chance of appeal is none. And sometimes when he feels a good connection with that client, he rewards them and be like, you know what, I feel like you were honest and you told me why you did this bad thing, and you might get a surprisingly low sentence. But here, he really, under national spotlight, told Alex Murdaugh, who was practiced before him, so it's personal, how he feels, that he believes he can't sleep at night, that he's probably haunted by his wife and his son in his sleep. He used the word monster. I mean,
it was very chilling.
He's thinking the jury has done their job, now it's my turn. And I'm gonna send a message. So, but then you get this, Rule 29B, motion for after discovered evidence. You can't ever imagine this would happen. And now, normally he's being tasked with deciding this very weighty thing. And now you're going to have the defense lawyer saying, well, number one, you're a witness, so you really shouldn't preside over something that you're a witness to. And number two, can you be fair and impartial when you've said he's a monster and that this is one of the most heinous things you've ever seen? I mean, I don't know. I think that would probably weigh on the side of the defense to say no, but if not him, then who? If it doesn't even get heard until he gets retired, well, then it goes to some other judge that's appointed or, administratively decided to handle this very important issue. It's pretty unheard of.
And one thing I want to make clear is that the law says a new trial must be granted unless it clearly appears the subject matter of the communication was harmless and could not have affected the verdict. So unless these jurors get up there and do an about face on these affidavits, which I don't see that happening, a new trial should be granted. And looking at social media, everyone's talking about this case, and a lot of the SLED's investigating, and they want to talk to the other jurors. This is not like a weight of the juror kind of situation. It's not like 10 of them say that the 2 are liars. That's not the analysis. It's, did a communication occur? These 2 or 3 say yes, it did. Now let's assess the communication. Was it harmless? Was it about the subject matter? Yes, it was. And was it harmless? So, and it's all, South Carolina is the smallest place in the world. So you've got some of these other jurors that potentially sleds want to talk to. Well, did juror number 785 really say that? Well, I don't know. It's about her fabricated Facebook post. I mean, what's that about? So some of these things they're not going to know. I mean, I guess some of these other jurors can say, were you allowed smoke breaks? Because apparently Ms. Hill didn't allow any of the jurors smoke breaks during the deliberations. And there were 6 smokers on the jury.
Wow.
And she just said, all right, you've been smoking. We've been having breaks, regular breaks, so you can be attentive to the proceedings.
And relaxed and comfortable.
And relaxed, because if you smoke, you smoke. And if you don't, you don't. But there's no real in between, right? And so if you're taking smoke breaks during your job.
You might start if you're on the jury for this
and
trial.
because you want to be comfortable and attentive, and all of a sudden the most important part about deliberation, hurry up, game over. And so that happened.
Me this little handmaid's news.
So that happened. And so I guess you could say, well, did that really happen or not? And I guess, it's good.
If you don't get this thing decided before dark, we're going to put you in hotels.
So that's the other thing. She also didn't mention, she apparently, per these affidavits.
And it's going to be a Best Western.
Per these affidavits, she says, hey, by the way, you better hurry up, because if it gets dark and we're deliberating, we're going to usher you up to hotels.
Whether you pack your bag or not.
And, we'll buy a toothbrush and throw a croissant at you. I mean, and so these jurors are freaking out about that.
They're becoming unhinged.
So that's the type
having
of
a cigarette.
that is the type of pressure that should not be happening, in all honesty.
And that happened with you guys one time, right?
We got, in our last
They weren't
trial, we were
offered dinner?
pretty upset because they were not ordered dinner as a matter of course. They were just kind of tossed some crackers, and we were like, hey.
It was 9.
Feed these folks.
It was 9 or 10 at night, and it was a younger new judge who we really liked. By the way, we really like this judge, but it could have been his first jury trial. And the clerk of court, who was the deputy clerk, just gave them little crackers and peanut packets.
And they sent out a note saying,
We're hungry.
Can we get dinner? And we're like, yes.
They're like SOS.
So just for
basically, yeah.
just
You're
for a
not
frame,
intermittent fasting.
just for a frame of reference, that really pissed us off.
Yeah,
And that was not a clerk of court interrogating and fabricating. That was just her not doing her job of ordering dinner for these folks. If the judge is going to keep them out to deliberate, order dinner, keep them comfortable. And so that.
And then they did get dinner, deliberated another 4 hours, and then had to go home because they needed to come back. But what if they'd never had dinner and just were starving and it was 11 o'clock and they're like, screw it. They might have decided that night even more harshly than they ended up deciding.
Right.
But so all that matters. That is a safe, sacred place for thoughtful analysis and comfortable discussion about, evidence, and you have to weigh it. And you can't do that if you're starving or scared or bullied or pressured.
Or fiending for a cig.
Right. So.
Dang, that's crazy. Would you say that when juries kind of feel that pressure to decide, do you think that it sways one way or the other more commonly? Do you think people are more quick to make a guilty verdict, or are they more quick or does it just depend on the case?
I think it depends on the case.
Yeah.
But they are quick to decide. And there's something called an Allen charge that really is designed to light a fire under them. And in our last trial, we did have an Allen charge, and once they claim that they're struggling or deadlocked, then the judge is supposed to give them this charge. It basically says, you're the best jurors we could possibly imagine. No one can do a better job than you. Please keep deliberating. It might result in a mistrial. This would be some other jury, some other day would have to hear all this. It basically encourages them to make them feel like, hey, you're in the best possible position. No one else can do it. This is your job. Go do it. And then usually that's like, hey, all right. So come on now. We don't want this. And usually it's not long after that. So you also have to really, it has to be said the right way. You can only give it once. You can't give them that charge again. And so it does matter, and that typically gets them across the line one way or the other. And sometimes they have notes, and they want things that are really, I mean, if a judge, like Judge Newman doesn't allow them to take notes for whatever reason, that's his
No
thing.
matter what the case.
No matter what the case.
It's just not his
Well, I
thing.
know why. He says, I don't want a
Right.
juror to write something down, and then maybe another juror doesn't write that bit down, and in deliberation, that juror's note, maybe it's taken down incorrectly, it becomes a focal point and it can be given more, weight than what it should be if you write it down and maybe someone else didn't, and you so he doesn't want that.
Some judges are like, here, who wants a notepad?
Right.
So you've got like,
Yeah, they're monitoring one.
you might have a juror or jurors who like can go, I remember that witness said that, but they're also, maybe they're missing something because in the moment they're not engaged and they know something was said, but they couldn't really feel whether it was credible in their own mind. So I think it's a split on what judges want to do. It's very much a personal preference.
What do you guys prefer? Do you guys like to have a jury that keeps notes or not?
Depends on the case. I think if it's like a super scientific case where if we're struggling on the defense and we need them to latch onto one super salient point, if I get that point out,
I'll just say,
I might be like, write that down.
You might want to erase
I
it.
will say this. We had a jury trial 3 weeks ago with a judge that allowed notes. And only the alternate asked for a notepad. And I really wish she was on the jury.
Mm-hmm.
And I had to do some math with a very key witness. And the math, I was able to publish it to the jury based on a rule of evidence that even though, I was extrapolating numbers and I kind of added it up and I left it up on this big video, document viewer for the jury for 10 minutes with the tally.
Mm-hmm.
And I was like, surely they're going to remember this number, right? And then they didn't. And their note back in deliberating was, can you tell us what that number was? Because that's important to us. And I was just like,
And the alternate
no.
had been excused.
And the alternate was gone.
She's the one that had the number.
So I wish, some of them had written that down. That would have been very helpful to me. But so I like notes personally. But
I'm torn. If it's a short trial, it's all based on like emotion and feeling. No, but if it's a longer trial and there's data and scientific evidence, it couldn't hurt to write down that opinion from that expert that might be important. But sometimes when they come back, they want things they can't have. And the judge has to say, well, you just have to rely on your own memory and recollection of the testimony as it came from that witness stand. And sometimes, sometimes they want to be recharged on the law, which means they're thinking about the language of the law. And that's fine. I think my favorite juror questions ever, it was a domestic violence case where the woman was pretty obviously not telling the truth. And she claimed that, well, my client said that she was mad. He came home and was staying out late, and he's really a big guy, and that she kicked him, tried to kick him in the bed, but she was so little that she ended up kicking herself out of the bed and then fell and hit her knee on her face. That was our theory of defense.
that's a pretty loose theory of defense.
Well, anyway, but the jury questions were.
I don't know the physics.
The jury questions were.
Well, I think it's right. You said that her injury wasn't domestic abuse, but it was she kicked herself out of bed on one.
Because he's so big, she pushed off.
And then she bashed her own face into her knee and she hit the floor.
Oh, that's okay. She'd have to
So
bring it back in.
It was like, boom, she hit back. So anyway, that was our theory, okay?
I don't know if I buy that
But
one.
the juror question, now this is one of those short, sweet, emotional trials.
Okay.
But the juror questions were the floors hardwood or carpet? And did she even have a job?
And what was she
And
wearing?
as soon as we heard that one, I was like, all right. And does she even have a job?
Did she have a job? And what was she wearing? She's probably asking for it.
Anyway, it was interesting.
Oh.
They were clearly buying into being kicked out of bed. So anyway,
Yeah.
sometimes
Hardwoods or carpet?
sometimes juror questions can be very telling. You're like, oh gosh.
I feel like we should do a whole episode just on silly jury quotes.
And sometimes it's like reading tea leaves. And remember we had that federal trial in January for a police officer that tased our client in her bed 9 times for no good reason.
Mm.
And the jury came back with a weird note. And one of our co-counsels was like, stood up and back in our conference room was like, all right, it's over. We're done. This case is sunk. Client, do you agree? What are we going to do about it? And I'm like, what? No, you can't make that claim just from that.
What was the question?
I'm trying. It was, well, it was a question about, I mean, that's a totally different world. It was a civil case. We're trying to claim multiple occurrences of injury. And he felt very pessimistic about the question and whether we would even have a win at all. But he got that wrong and we did. So, but sometimes you just can't tell. You just can't tell.
Yeah.
I find it's one or the other. Either it's so obvious or you can't tell at all. So anyway.
So there's obviously talk of there being another trial, the sequel.
Wow.
Which is wild. What would the logistics look like? Like, would this have to be relocated? What are the chances that a jury would come back with a new verdict for Alex Murdaugh?
Well, I think, let's just say he gets a new trial by Judge Newman just for this jury tampering. I mean, so what's really interesting is if that were the case, then there's no reason to say that the major issues that I think shaped his conviction, other than his perhaps guilt, like the 404B, the bad character financial crimes evidence, like if Judge Newman just said you get a new trial, that doesn't mean that all that just wasn't coming in. But if it went up on appeal and the court said that should not have come in, that was wrong, go back and have a new trial, well, then the new trial judge has that in knowledge. So they know under this case it should not have come in and it was error. I mean, that makes all the difference in the world. So, so those are huge questions, but the question of like, if it happens exactly like it did, but it's just a new jury because Becky screwed it all up, he probably goes down. But if there's some appellate issue that says they shouldn't have heard about all the financial crimes, he didn't open the door to it, and guess what? That is attempted suicide is just so prejudicial that he couldn't have gotten a fair trial. If he didn't have those things, new jury, I mean, you never know whether they do it in Colleton County or not. I mean, there's not a place in the world that hasn't heard of Alex Murdaugh, but from a structural, institutional, I mean, this is an allegation that the institution, the county of Colleton, from the clerk of court, meant to subvert this process. So I think if there was another trial, they could, with a straight face, say, he can't get a fair trial here. We need to go, I mean, everywhere people would have heard of him, but let's go to Richland County. Let's go to, I mean, it has to be in the state, but you can have a change.
That is a good point. So let's say Newman grants a new trial and, got to get scheduled. It's got to get, I mean, what's happening to Becky Hill? She's gonna be, she's gonna be under investigation. So, and then you made an allegation. So let's say she's still the clerk of court when this gets, so she's got to either resign, she's got to be suspended, she's got to step down. And then let's say a deputy clerk step forward and says, I can do this job.
Becky hired them.
Yeah, exactly. Becky's been my mentor for 15 years. So that may be a good grounds to have it go to a different county.
Mm-hmm.
It's very interesting, but you're right. I mean, who doesn't know about this trial?
But they'd have to be vetted, and of course that'd be fair and impartial, but I think it's worse if Newman grants this for the defense, because he's not re-ruling on the 404B issues. He's just saying, that jury got tainted by Becky, go redo it.
Oh, Lou, I think Alex Murdaugh would probably beg to differ if it's worse for him if he gets a new trial.
Well, I know, but let's just say, assuming he gets a new trial, let's just say that. I think it'd be better if the Court of Appeals has the issue of 404B, because so they can instruct the new trial judge for him. But
That's an academic argument. Well, here's one thing I would say on that point.
I'm an academic guy.
Sometimes. Well, think about this. Think about this, sir. Judge Newman initially kept out the financial crimes.
Right.
And then he said that Jim Griffin opened the door.
Right.
So the initial ruling was it stays out.
But did he really open the door? Which I don't think he did.
Well, I guess I'm saying, let's say this gets to be a new trial with a new judge. It's fascinating.
You're saying it's not a foregone conclusion, it just comes in.
No, it's not. But we've also had all this testimony to it. So there's some massive pretrial rulings that would have to happen.
And now he's pled to a bunch of the financial crimes, awaiting sentencing.
Right. And he only probably took the stand, he would say, because of the financial crimes coming in. So
Well, that's why
it's become full circle.
That's why his testimony took multiple days instead of just several hours.
Yeah.
Well, fascinating.
Most importantly, leave Buster alone.
Leave Buster alone.
Yeah. Well, I think Buster would love for his father to get a new trial. And, he did an interview recently. I don't think the conviction has changed his opinion that his father is innocent. So I think he's fully in support, and
there's still a lot of unanswered questions.
Right. I mean, Murdaugh's going down he's going to be in prison the rest of his life. The question is it going to be for the murder of his wife and son after this craziness with Becky Hill? Oh, Becky, we've said this before, but Creighton Waters, who did a great job on this prosecution, is probably just wants to strangle Becky Hill.
Yeah. I mean, do you think that Dick Harpootlian is super excited to get back in the ring?
He always is.
Oh, okay.
He never wants to stop fighting. He's always ready to get back in the ring.
Well, then there you go.
Yeah.
It'll be a good match. I think we'll wrap it up there. This was our first try on StreamYard and YouTube Live. I think it went well. We have a lot of room for growth, but really enjoyed testing this with you guys. Please feel free, if you ever have any questions or cases that you want to learn more about, give us a comment, slide into DMs, let us know what you guys are interested in at the moment. And yeah, this has been Bring the Jury with Luke and Brian Shealy. Bring the Jury. We might be hearing that again very soon.
Oh, yeah.
So thank you guys, and we will see you next time.